How do disability insurance companies make it difficult to win your claim in court? Hi, I'm Mark Whitehead, a board-certified disability attorney and author of the Disability Help Book, Disability Insurance Policies, How to Unravel the Mystery and Prove Your Claim. Long-term disability insurance claims can be difficult to effectively litigate in the federal courts in Texas. One of the difficulties for claimants to overcome is the restrictive discovery rules that have evolved from the common law governing the Employee Retirement Income Securities Act, or what's known as ERISA. ERISA applies to most disability insurance claims. Discovery refers to the ability of the parties in the litigation to request information from the other side, such as in the form of written questions or oral depositions of individuals. Disability insurance companies effectively use ERISA as a shield to deny claims. Insurance companies such as Unum, Cigna, MetLife, The Hartford, and Aetna typically use ERISA common law as a shield and take the position that they don't have to comply with the disabled claimant's discovery requests. The goal of the insurance companies is to prevent the claimant from investigating whether their claim was fairly handled under the rules. In the Fifth Circuit Court of Appeals, they've relied on a court opinion in Vega versus National Life Insurance Services to argue that the only admissible and therefore discoverable evidence in an ERISA action was first, the administrative record, second, evidence involving the interpretation of the plan, and third, evidence explaining medical terms and procedures. This interpretation has greatly hindered the efforts of long-term disability insurance claimants to investigate and prove abuse by the insurance companies. However, this unfair rule has been changed for the better recently because of two recent cases. The U.S. Supreme Court recognized in Metropolitan Life versus Glenn that when a plan administrator both evaluates claims for benefits and pays the benefit claims, it creates a structural conflict of interest. The level of conflict is a factor in determining the court's standard of review. Therefore, a claimant is entitled to some level of discovery on the issue of the insurance company's own conflict of interest. Also, the Fifth Circuit Court of Appeals in Crosby versus Louisiana Health has recently held that discovery is permissible on the extent and existence of a conflict of interest. Further discovery is permissible regarding the completeness of the administrative record and of whether the plan administrator complied with ERISA procedural rules. In using the words existence and extent of a conflict of interest, a plaintiff can argue that the individual conflict of interest of the administrator's employees, agents, and consultants are discoverable as well. The moral of the story is that the courts are starting to wake up to the fact that insurance companies are trying to hide the ball in disability claims, and this is a good thing for a disabled claimant. For more information on this topic, check out my free ebook, Disability Insurance Policies, How to Unravel the Mystery and Prove Your Claim. Visit www.disabilitydenials.com for a free downloadable copy, or call 1-800-562-9830 to discuss your particular disability issue. I'm Mark Whitehead. Thanks for watching.